Hello everyone, very warm welcome to StudyIQ IS English channel. I am your educator Praveen Mishra and let's start the very second chapter in our Indian polity series. As in the previous chapter we discussed about the basic features, or simply speaking the salient features of the Indian Constitution, and in that the very next chapter was to be discussed was the sources of the Indian Constitution. So here we are with the very next, that is the second chapter. So what are the sources actually? The Constituent Assembly that was established in the year 1946 or December 1946 took around 2 years, 11 months and 18 days to frame our wonderful constitution, no doubt in that. So, what are the sources the makers of the constitution or the whole of the Constituent Assembly opted for? Let's discuss each and every single source in depth, in detail. So, as you can see, the very first ever source, that is named as the Government of India Act 1935. It was the lengthiest ever act passed by the British rule, the British government inside India. Lengthiest as in, as you can see, the constitution was a byproduct of the legacy started by the Government of India Act of 1935. This was the longest act passed by the British with around 321 sections and 10 schedules. So you can understand the vastness of the act. Government of India Act 1935, around 321 sections divided in 10 schedules, and this act has had drawn its content from 4 sources. Now, yes, the sources of the Indian Constitution, one of the sources is the Government of India Act 1935. Now, what are the sources of Government of India Act 1935? So, the Government of India Act 1935 draws its sources from 4 different areas. That is the report of the Simon Commission, that is in the year 1928. Next, the discussions and deliberations at the Third Roundtable Conference, that is in the year 1932. Then the White Paper of 1933, which was the outcome of the Third Roundtable Conference itself. And the fourth one, the multiple reports of the Joint Select Committees. Okay. So out of 4 sources, 3 are distinctly clear. That is the first one being the Simon Commission report, second one being the Third Roundtable Conference of 1932, and the third one being the result or the aftermath only of the Third Roundtable Conference, that is known as the White Paper 1933. So these are the 3 defined sources, and the fourth one will be the sources, actually the report of the Joint Select Committees. Right? So, Government of India Act 1935, what are the provisions that we have opted from the particular act? As we can see from the act, it abolished the system of provincial diarchy. Okay, simply what? It abolished the system of provincial diarchy. That means there were no dual governments inside the provinces, basically the states, and suggested the establishment of diarchy at the center and a Federation of India consisting of the provinces of British India that were mostly the princely states. Okay. So simply speaking, the Government of India Act 1935 abolished the dual role, the dual government, the diarchy in simple terms in the provincial level. And it suggested for having diarchy at the central level with the second government acting into the provincial, that is the state levels only. So, most importantly, the act established the office of governor. Governor where? Governor of provinces, that is modern times, the states. So, as we can see, we have got the dual government in India, the central government as well as the state governments. So, this is what was mentioned in the Government of India Act of 1935, and we have got the governors of the states as well. Each and every state along with the union territory possess the governor or the lieutenant governor. So this is what the outcome of the Government of India Act 1935. Next, think. Federal legislature. As we can see, the act suggested that the legislature will have 2 houses. That is, the Council of the States and a Federal Assembly. The Council of States was the upper house, which was literally a permanent body with a tenure of 3 years, and composed of 260 members, out of which 160 were the representatives of the British Indian Territory and the rest 101 members were the from princely Indian states. The Federal Assembly was the lower house with a tenure expanding up to 5 years, and its composition included 250 representatives, okay, British India 125, okay, 250 representatives of British India and 125 members from the princely states, right? So as in the present time, what we have in our parliament, we have got the bicameral legislation, that is simply speaking Lok Sabha and the Rajya Sabha. Rajya Sabha being the upper house and Lok Sabha being the lower house. Rajya Sabha, that is also named Council of States, whereas Lok Sabha remains Lok Sabha, that is the House of People. So this is the provision which we have adopted through the Government of India Act 1935, the things that are mentioned here. Okay, so this is also the outcome, the bicameral legislation, this is also the outcome of the Government of India Act 1935. Next thing, provincial autonomy. This act enabled the provincial governments to be responsible only to provincial legislatures and helped them break free from external control and intrusion. It was with the establishment of this act, the powers between the centre and provinces were divided in terms of the three lists. That is a federal list with 59 items in that, the provincial list with 54 items, and a concurrent list with 36 items for both. And the fourth one was the residuary list, which was centered into the hands of the Viceroy only. So at present, when we talk about the present system of the distribution of powers between the centre and the states. So what we have got under Article 246 mentioned in Schedule 7. What do we have got? We have got a central list. Another we have got state list. And then we have got the concurrent list as well. And beyond that, we have also got a residuary list, that is those matters which are mentioned in none of them. Okay, that is what is known as residuary, right? So central list, who can make laws? Centre only. State list, who can make laws? State in normal circumstances, that is if there is no emergency, president's rule, or a resolution passed by Lok Sabha, that's like that. That is in normal situation. And concurrent list, who can make laws? It will be the centre as well as the states. But in case both of them have legislated, whose law will prevail? Obviously, it will be the central law which will prevail. Okay. So this is what presently we have got in our Constitution of India, independent India. So something, as we can see, the remnant, okay, or the eclipse from the Government of India Act of 1935, okay, here this is what exactly is mentioned. So it distributed the list, it distributed the functions, the powers of legislation between the centre and the provinces, along with the concurrent one, though the concurrent one here right now, it lies with both centre and state. At that time also it was lying with both, but the residuary presently, it lies with the centre, and at that time it was lying with Viceroy. Just the basic difference. Next thing, the United Kingdom. When we talk about what are the things we have adopted from the country of England or the whole of the United Kingdom. So the first thing, that is the parliamentary form of government, as we were discussing into the salient features chapter as well, that is the very first chapter. Okay, in that we discussed that is the prime ministerial form of government, or Westminster form of government, or cabinet form of government. We have adopted it from where? We have adopted it from the country of England. Now, as you can see, the next thing here, prime minister is the head of the government. Yes, whereas the president is the nominal head, that is the de jure head, and president is considered as the head of the state. The very main feature of the parliamentary form of government is the availability of one or more opposition parties that exists to keep a check on the ruling party. So the biggest feature of the parliamentary form of government is the existence of the multi-party system. And this multi-party system, which sits into the opposition in case they lose the elections, this opposition works as a catalyst to balance the democracy in order to avoid any kind of dictatorship. Right? So this is what the United Kingdom has given us. And one more thing, that is known as the rule of law. According to Article 14, what we have got. A.V. Dicey, the very great political philosopher and the scientist who coined this term, that is the rule of law. Right? He stated a country, a state, a territory should be governed only with the rule of law. The source of the law should be the people, but the people should not be the governing authority. It should be also not any other authority who should be governing. It should be only and only the law. Though yes, the source of the law should be the people. Okay, so it is what's stated here. This basically states that a state is not governed either by the representatives or even by the people, but only by the law of that country. So who is supreme? In any democracy who follows rule of law, the supreme authority is only and only law. That is, no one is above the law, first thing. And everyone is equal in the eyes of the law. This is what Article 14 of the Indian Constitution states that. Okay. Next, single citizenship. As we were discussing in the previous class as well. Like for example, America. It has dual citizenship. That is the citizens of America as well as the citizens of the respective states wherever they are residing. For example, citizen of America is there for sure. Apart from that, let's say there is a person who is residing in the state of California. So that person is also the citizen of California. But the twist here in the story is, firstly, that person is considered as the resident of California. And secondly, he or she will be considered as the American. So this thing is something which will trouble always the principles of harmony and fraternity, integrity and equality. So keeping this thing in mind, our constitution makers, the framers of the constitution, they just eliminated this concept of dual citizenship and implemented in the place, that is the single citizenship only. So who are we? Whether I am a resident of Kashmir, whether I am a resident of Tamil Nadu, Andhra Pradesh, Arunachal Pradesh, Nagaland, Gujarat, Rajasthan, UP, Jharkhand, Chhattisgarh, anywhere, I am only and only Indian. Okay, that is what the concept of single citizenship is. Okay. Next, USA. What are the things we as Indian citizens have got from the Constitution of America? So first and the foremost thing is that something that is known as in America, Bill of Rights. In India, we call it as fundamental rights. So part 3 of the Indian Constitution from Articles 12 to 35, all of them, what we have written inside our Constitution, yes, they are written as per the tradition, culture, aspects, requirements of the Indians. But the source remains as the United States of America, its constitution, right? So when we talk about right to equality, right against discrimination, religious rights or any type of minority rights, they are also as same as enshrined in the Constitution of America. Okay, so first thing, that is what? Fundamental rights. And apart from that, the next thing, judicial review. So it was the time period of 1803 or 1809, I believe, when in America a very famous case happened known as Madison versus Marbury. In that Madison versus Marbury case, the Supreme Court of America, it iterated or enunciated or stipulated simply the principles of judicial review or the doctrine of judicial review. That is, if a law made by the legislature or implemented by the executive is disturbing or violating any of the principles of the Constitution, any of the principles, not just the rights, but any of the other parts or the provisions of the Constitution, then the judiciary possesses absolute authority to declare that law as null and void. Right? So this is what the principles of judicial review is, and it has been originated in America and being adopted by the Indian judicial system as well. Okay, so judicial review and fundamental rights, both from where? Both from America. And apart from that, the third and the very next thing, that is the impeachment procedure of the president. Okay, is also adopted or followed by the American Constitution. As you can see here, the president, the impeachment of the president and the removal of the judges both actually. Article 61 of the Indian Constitution provides for the impeachment of the president through legislative procedure carried out by the two houses of the parliament, whereas Article 124 clause 4 of the Indian Constitution deals with the removal of the judges along with the Judges Inquiry Act of 1968. Though 1968 law is different, but just dealing with Article 124 clause 1, that is the removal procedure of the judges. So Article 61, that is the impeachment, once again it's removal, but we don't use the word removal with president, we use the word impeachment. So impeachment of the President of India, Article 61, and the removal of the judges of the Supreme Court, okay, that is Article 124 clause 4, they are also adopted from the American Constitution itself. Okay, so the three things are here in front of us, that is also from the United States of America. Next comes into the list Ireland. Part 4 of the Indian Constitution, that is Directive Principles of State Policy from Articles 36 to 51. They are adopted from where? They are simply adopted from the state or the country of Ireland. And not just the DPSPs. As we can see the last line highlighted here, the procedure for the nomination of the members to the Rajya Sabha is also borrowed from the country of Ireland. President, in its legislative discharge of functions, can nominate 12 members, those who are experts in the field of, call it literature, science, sports, okay, can nominate such persons, 12 such persons into the Rajya Sabha. Okay, so this is what a provision we have adopted from which country's constitution? It is once again Ireland. So apart from DPSPs, we have also followed the provision for the nomination of members by the president into the upper house, that is known as Rajya Sabha in case of India. Okay. Next thing, that is Canada. What are the things we have adopted from the Canadian Constitution? So the first thing, the provision of a federation with a strong centre, residuary powers of the centre, appointment of the state governors by the centre, and the advisory jurisdiction of the Supreme Court have all been borrowed from the Canadian Constitution. Right? See, how are the things? How many are the things? The provision of federation with strong centre first. Residuary powers in the hands of the centre second. Then appointment of state governors by the centre third. And fourth, advisory jurisdiction of the Supreme Court. They all are borrowed from the Canadian Constitution. Advisory jurisdiction of the Supreme Court, Article 143. Supreme Court can advise the Honorable President of India on two matters. That is the first one that is considered as the substantial question of law, and second one that is considered as a question arising out of any pre-constitutional treaty, covenant, sanad, etc. So in these two matters, the President, Honorable President, can seek advice from the Honorable Supreme Court of India. Okay. And in the first one, that is the substantial question of law, Supreme Court is not bound to provide the advice. Supreme Court may or may not even. But in the second one, that is any question arising out of the pre-constitutional treaty, covenant and sanat, in that case, Supreme Court is bound to provide advice to the President. though President is not bound to act on the advice rendered by the Supreme Court, but yes, Supreme Court is bound to advise the President into the second matter, that is the any matter arising out of the pre-constitutional treaty, etc. Right? So, Article 143. Another one, what we have got, Article 248, which says that the Parliament has the sole power to make laws on any matter which is not mentioned. Okay, which is not mentioned where in the union and state lists respectively, that is simply the residuary list. As you can also see, we have also discussed this thing while we were talking about the Government of India Act 1935. Viceroy was making the law at that time, right? The residuary one. But what we have seen in the state of Canada, it was a very wonderful thing that the residuary things were given to the centre only. So obviously, we have also given it to the centre. So this one is also followed by the Canadian Constitution. Next, the Constitution of France. 1789, the start of the very enormous revolution of this planet known as the French Revolution, which gave the principles of liberty, fraternity, and equality. And we were quite happy with these three terms. Our constitution makers, the framers, they were literally impressed with these terms. And so they did adopted the principles of liberty, equality, and fraternity from the French Constitution into the Indian Constitution. And further, the Indian state came to be recognized as the Republic, okay, which is also in the lineage of the Constitution of France. So two things. Firstly, what is we have written in our preamble, that is the three principles, liberty, fraternity, and equality. And apart from that, the Republic thing. We are Republic. Why? Because the state head is elected in India, not hereditary position. Just not like England, where the state head is still hereditary. Still, there is the crown. But in India, we do not have any crown thing, and the state of the head in India is elected, and hence that's why we are considered Republic, just like Republic of France. Okay, so two things we have adopted from France, the principles of liberty, equality, and fraternity, and second thing, that is the Republic. Next, Australia. The provisions of interstate trade and commerce, which is mentioned in our articles 301 to 307, is adopted from the Australian Constitution, that is interstate trade and commerce. First thing. And second thing, we also received the provisions of the concurrent and the joint sitting of both the Houses of Parliament. Okay, so under Article 108, President can call for a joint sitting of both the Houses of the Parliament over a deadlock with regard to any bill. Just the condition is it should not be the money bill as well as the constitutional amendment bill. Okay. So using that Article 108, President of India can call for the joint session of both the Houses of the Parliament, and this provision is also adopted from where? From the Australian Constitution. Okay, along with the freedom of trade and commerce, interstate trade and commerce, right? Next, South Africa. It gave us the election procedure of the members of Rajya Sabha. So the members of Rajya Sabha, they are indirectly elected. We do not vote for the Rajya Sabha elections, right? So they are indirectly elected by the members of the Lok Sabha itself. And this particular provision has been followed by where? By the state or the constitution of South Africa, right? So this is what the whole story with regard to South Africa. And the last one, we have got Germany. The provision of the suspension of fundamental rights during emergency, national emergency, once again has been followed by where or adopted from where? By the German Constitution. Okay. So Germany, suspension of fundamental rights during national emergency or the imposition of national emergency. These are the things being adopted by the different constitutions of the globe. Okay, everyone. So that's it with this session right now. Thank you so much for watching. And please do let me know your valuable feedback into the comment section and do subscribe for the channel as well. See you all in the very next session that will be there. We will be discussing about the establishment and the functioning of the Constituent Assembly. Okay, guys, stay tuned with the channel.